Hi everyone, my name is Benedict Xiaosongkai, and today I will present to you the comparative studies of the different construction standards form of contract. So what is standard form of contract? In the construction industry, contract is one of the most important elements throughout the whole pre- and post-construction phase. A standard form of contract is a contract which bound two construction parties, where the terms and conditions are set by one side of the contracted parties and the other parties has no abilities to negotiate for better conditions or terms, but he has to either accept it or deny it. So in Malaysia, there is some commonly used standards for a contract. So here I will give out 4 examples. So the first one is PAM contract form 2018. This is usually for the private sector, and this is the traditional general contract. And for the second one, is PWD form 203A. This is from the JKR, and this is usually used for the government and public sector's use. So the third one is FIDIC Web Book 1999. So this standard form of contract is used when the construction contract are expanded to the international aspect. So and the last one, it will be the CIDB Standards Form of Contract for Building Works 2000. It is in the respect of design and build and also the civil engineering works. So today, we are going to discuss about the difference for the standard forms of contract. So the difference of the standard form of contract can be decisive for the construction players to be familiar to which standards form of contract is more suitable for the current construction projects he is handling. So the obligations and procedures are differently mentioned and slight discrepancy of the wording expression in the context of every single standard form of contracts. So here is the findings of the difference of four standard form of contracts mentioned earlier: the PAM, the PWD, the FIDIC, and also the CIDB. In the certificate of extension of time (EOT), the certificate of making good defects, the certificate of practical completion, the CPC, and the certificate of non-completion, the CNC, and the last is the termination of the contract by the employer. So for the first one, we will discuss about the certificate of extension of time. It's commonly known as the EOT. So the EOT is stated in PAM under the clause 23, extension of time. So in PWD, the EOT was stated in clause 43, the delay and extension of time. And in FIDIC, there is 3. The EOT is stated under clause 8, commencement, delay, and suspension, and also clause 19, the force majeure, and also the clause 20 about the claim, dispute, and arbitration. And in CIDB, the EOT was stated under clause 24, the delay and extension of time. So the first thing we'll talk about is the contractor's obligations. So in PAM, it's stated in clause 23.1a, the contractor should issue a written notice to the architect within 28 days from the date of the relevant event that caused the delay to claim for the estimated extension of time needed. So in clause 23.4, it stated that the architect may issue the notice of rejection or the certificate of extension of time after the consideration of the proposed claim of the contractor. So under clause 23.6, it stated that the contractor shall constantly use his best to prevent or reduce delay in the construction work's progression, and this is to ensure the work done within the completion date. So in the second standard form of contract, PWD, the contractor's obligations is stated in the clause 39.1. The contractor shall complete the whole of the works on or before the date of completion as stated, or such extended time as may be allowed under clause 43. So in clause 43.1, the SO may, if he is of the opinion that the EOT should be granted, the certificate of delay and extension of time with reasonable extension of time can be issued as soon as he is able to estimate the delay beyond the date and time. So also in the 43.1, the clause 43.1, the contractor should always take all reasonable steps to avoid or reduce the delay. So in the third standard form of contract, in FIDIC, the contractor obligations is stated in clause 8.4. The contractor shall give notice to the engineer in accordance with clause 20.1. So also in clause 8.9, the contractor shall not be entitled an EOT due to the contractor failure to protect, store, or secure in accordance with the clause 8.8. So in the clause 19.4, if the contractor is prevented from performing any of his obligation under the contract by force majeure, under clause 19.2, the delay caused by it can be granted EOT. So in the last standard form of contract, CIDB, the contractor's obligations is stated in clause 24.1. The contractor shall not be entitled to any EOT if there's contractor breached the contract. And also in clause 24.2a, the contractor shall notify the SO of the event of delay and the estimated EOT within the 30th day. So in clause 24.4a, a delaying event has a continuing effect such that it is not practicable for the contractor to submit all information in accordance with clause 24.2. He shall be entitled to EOT. So in the procedures of how to claim the EOT in PAM, is stated in clause 23.1. The first thing is the contractor should issue a written notice to the architect within 28 days from the date of the relevant event that caused the delay to claim for the estimated extension of time needed. So secondly, in clause 23.3, the appeal with insufficient information of the event can be rejected by the architect, and the contractor should be informed to resubmit the claim within 28 days or so. So lastly, clause 23.4, the architect may issue the notice of rejection or the certificate of extension of time after the consideration of the proposed claim of the contractor. So the procedures in PWD will be a little bit different. So the first thing is that the whole procedure is stated in clause 43 in PWD. The first thing is that the contractor shall forthwith give written notice to the SO as the cause of delay and relevant information with supporting documents and calculation of the length of the delay. So secondly, the SO should grant the EOT to the contractor if the work delay is caused by the other events stated in the condition precedence later. So lastly, the contractor shall not be entitled any EOT where the instruction or act of the SO are necessitated by or intended to remedy any default of or breach of contract by the contractor. So the procedures of claiming EOT in FIDIC is stated in clause 20.1. First thing first is that the contractor shall give the notice to the employer describing the event giving rise to claim not later than 28 days. So secondly, the contractor shall also submit any other notice which required by the contract to support the claim. So lastly, the contractor shall keep such contemporary record as may be necessary to sustain any claim. So the procedures in CIDB is stated in different clauses. So the first thing is the clause 24.2a. The contractor shall notify the SO of the event of delay and the estimated EOT within 30 days. So secondly, in clause 24.2b, the SO may require the contractor to provide further information of the event if the submitted notice is not sufficient. So in clause 24.3c, the SO shall nevertheless grant the EOT as the delay appear to be fair and reasonable. And lastly, the clause 24.6, the SO shall give the certificate of EOT to the contractor and a copy of the and a copy to the employer. So in the condition precedents, in PAM stated that in clause 23.8, the relevant event that can be granted EOT referred in clause 23. So the first thing is the force measure, and the second will maybe the exceptionally inclement weather, and the third one is the loss or damage occurred not due to negligence of the contractor, and that the severe commotion or lockout affecting the preparation of transportation of the materials and goods. And next is the contractor not receiving any necessary document in time, and also the contractor not receiving necessary AI in time will be the condition precedence, and also delay caused by the employer, not the contractor, and also the compliance with AI issues by the architect, and the delay caused by the nominated subcontractors for reasonable events, the renominations of not nominated subcontractors, the delay caused by the craftsman, tradesman, or other contractor employed, and also the employer delay or fail to supply the works after promised commitment. And then the opening up of the inspection of any work cover-up or testing of material goods, any acts of prevention or breach of contract by the contractor, and also the war damage will be under the consideration. The compliance with AI issued in connection with the discovery and ticks, and also the compliance with any charges to any law, regulations, terms, and conditions of any appropriate authority and the service provider, and also the delay caused by the appropriate authority and service provider, and also the appointment of a replacement person, and also the compliance with AI issued in connection with dispute with neighboring properties owners which is not caused by negligence of contractor. The delay as result is if the execution of work is in the opinion of architect, and also the failure of the employer to give the site position to entry or exit the site, and also the suspension by the contractor of his obligation, also the suspension of works by order and of an appropriate authority which is not due to negligence by the contractor, or any other ground extension of time especially as stated in the contract. So under condition precedents in PWD, is stated in clause 43.1, EOT is granted if the works delay due to appendix 1 of following event. A. First thing is a force measure as provided under clause 58, and then the exceptionally inclement weather, and also the suspension of works under clause 50, and also the SO's direction consequential upon dispute with neighboring owners which is not due to any negligence of the contractor, and then also the such SO instructions are not issued due to any negligence or breach of this contract by the contractor, and also the contractor having received in due time instruction in regard to the nomination of the subcontractor or suppliers provided in this contract, and also the delay in giving possession of the sites as provided under clause 38.4, and also the delay on the part of architect, the tradesman, or the others engaged by the government in executing the work not forming part of this contract. The contractor's inability for reason beyond his control and which he could not reasonably have foreseen and are essential to the carrying out of works, and also or delay or on the part of the nomination subcontractor or suppliers to perform their works as clause 43.1a and I. And feeding the under condition precedents, first thing is that the EOT shall be entitled due to events stated in clause 8.4. First thing is that a variation or other changes in quantity of an item of works included in the contract. The second is a cause of delay giving an entitlement to extension of time under a subclause of this condition. So the third one is exceptionally adverse climatic condition. The fourth one is unforeseeable shortage of in the availability of personnel or goods caused by epidemic or governmental action. The last one is a delay, impediment, or prevention caused by the attributable to the employer. And second, the following condition apply, namely, the contractor has diligently followed the procedures laid down by the legally constituted public authorities in the country. And then these authorities delay or disrupted the contractor's work, and also the delay or disruption were unforeseeable. So, and also in FIDIC, the third one is the force majeure may include due to events as follow. First one is war, hostilities, invasion acts, or foreign enemies. And the second one is rebellion, terrorism, revolution, insurrections, military or usurped power, or civil war. The third one is riot, commotions, disorder, strike, or lockdown by a person other than the contractor. The fourth one is munitions of war, explosion, materials, ionizing radiation, or contamination of radioactivity. The last one is natural catastrophe, such as earthquake, hurricane, typhoon, or volcanic activity. So under this condition precedence of CIDB, clause 24.1 stated the works may be extended due to reasonably delay as the following events: a force majeure, and also exceptionally inclement weather, the industrial trades delayed in preparation, manufacture, or transportation, and also the one or more of the expected risks, and also the contractor not having received any necessary drawings or instruction from the SO within the reasonably time, and also an instruction from SO to resolve the discrepancy in the contract documents pursuant to clause 10.2. Also compliance with statutory requirements for which the employer is responsibility under clause 10.1, and testing by the SO which is not provided in the contract pursuant to clause 15.4, and also the failure of the employer to give possession of sites as required in clause 17.2, and the acts of nominated contractor by the employer in executing works not forming part of the contract, and also an instruction by the SO to suspend any work, and also the variation, and also the damage and loss covered by the insurance policy referred in clause 38.a BC, the issues in respect of antiques or forces under clause 39, the issues in relation of prime cost and provisional sum item which give rise to a variation, and also the delay or the nominated subcontractors of suppliers, and the last is any other grounds or EOT expressly mentioned in the contract. So in the clause of EOT, the main difference of these four standard form of contract are the time duration to submit the notice of the event of delay and claim for the EOT. So for PAM and FIDIC, it stated that the notice must be submitted within 28 days to the architects and employers. So for CIDB, it stated that the notice must be submitted within 30 days to the SO. So for PWD, there is no specific time duration stated for the issuance of notice within the date of delay event. And all these standards for a contract, the contractor is needed to issue a notice of the event of delay and shall ensure the works done before the completion of date to avoid delay. So the procedures of the claim of the certificate of EOT, similar as starting with the issue notice of delay, then after getting approval from the employers, the contractors will receive the certificate of EOT. So in the second certificate, the certificate of making good defects, so it's stated in PAM in clause 15, practical completion and defect liabilities. So in PWD, it is stated in clause 39, completion of works, and also the clause 48, defects after completion. So in FIDIC, it is stated in clause 11, the defects liabilities. So in CIDB, it's stated in clause 27, defect liabilities after completion. So the certificate of making good defects in the contractor's obligation in PAM stated that in clause 15.3, the contractor shall comply with his undertaking to attend to the works and defects of a manner nature under clause 15.1 within the specific time. So clause 15.4, the contractor shall make good the defects specified within 28 days after the receipt of the schedule of defects during the defects liability period, the DLP. So the clause 15.6a, the architect shall issue the certificate of making good defects if the contractor has made good of all defects. So in the PWD, the contractor obligation is stated in clause 39.4. The contractor shall not be issued the certificate of partial completion, the CPC, until the remedial works up to defects were carried out by or done by the contractor. So also in clause 48.1a, the SO shall issue a written instruction to the contractor to make good such defects at the contractor own cost within the defects liability period. And also in clause 48.4, the certificate of making good defects shall be issued by the SO to the contractor if the contractor has made good all defects within the specific date. So in FIDIC, the contractor obligations is stated in clause 11.1. The contractor shall execute all works required to remedy defects as notified by the employer before the defects notification period. So also in clause 11.2, the contractor shall bear all the costs and risks of the remedy works of the specified defects. So in clause 11.5, the contractor may remove the defects cannot be remedied on sites for the purpose of repair such item of plants as are defective. So also in clause 11.9, if the contractor has done remediate all defects, the engineer shall issue the performance certificate to the contractor within 28 days after the latest expiry date of the defects notification period. So in the CIDB stated the contractor obligation under the clause 27.1 during the defects liability period, the DLP, the contractor shall complete with due expedition or within such time as may be specified by the SO. So in clause 27.2, all works referred to in clause 27.1a and b shall be executed by the contractor at on close. So in clause 27.3, if the contractor default in carrying out his obligation pursuant to clause 27.1a and b, the employer shall be entitled to employ and pay others person to carry out the same. So in clause 27.6, the certificate of making good defects shall definitely discharge to the contractor from any physical attendance upon the works of the purpose of remedying defects. So in procedures of making good defects, PAM mentioned in the clause 16.4 to 6. So first is that any defects appear within the DLP shall be specified by the artifact in the schedule of defects to deliver to the contractor. And secondly, the contractor shall make good the defects specified within 28 days after the receipt of the schedule of defects during the DLP. So the third one is the thing to do is that if the contractor fail to make good of the defects, the employer may employ other person to rectify the defects, and all costs incurred shall be set off by the employer under the clause 30.4. Lastly, the architect shall issue the certificate of making good defects if the contractor has made good of all defects. So in PWE, the procedures is mentioned in clause 48.1a. The DLP is about 12 months from the date of practical completion. If in clause 48.1a, the defects liabilities period is about 20 months from the date of practical completion. So in the SO shall issue written instruction to the contractor to make good such defects at the contractor on cost within the defect liability period. And lastly, the contractor shall complete the works within the specified date. And the PWD also mentioned in clause 48.1b without prejudice to A. The SO shall deliver the schedule of defects to the contractor not later than 14 days. The specific defects in the schedule of defects shall be made good by the contractor at his own cost. So in physics, the procedures of making good defects is stated firstly in clause 11.1. The contractor shall execute all work required to remedy defects as notified by the employers before the DNP. This is DNP. In physics, it's called DNP. And clause 11.2. The contractor shall bear the cost and risk of the remedies work of the specified defects. And in clause 11.4, the contractor shall if the contractor fails to remedy the defects by notified days, the employer may carry out works by himself or the other contractor's cost, or require the engineer to agree a reasonable reduction of contractor price in accordance with clause 3.5. So in the last one, the clause 11.9, the contractor has done all remedied all defects, and the engineer shall issue the performance certificate to the contractor within 28 days after the latest expiry date of the defects notification period. So in the procedures of making good defects in CIDB, it's mentioned in clause 27.1. During the defects liability period, the contractor shall complete with due expedition of within such time as may be specified by the SO. So secondly, is the clause in clause 27.3. If the contractor defaults in carrying out his obligation pursuant to clause 27.1 A and B, the employer shall be entitled to employ and pay other person to carry out the same. So in clause 27.5b, if the contractor is liable for such defects under the contract, the cost of the work carried out shall be borne by the contractor at on cost. So lastly, the clause 27.6, the certificate of making good defects shall finally discharge to the contractor from any physical attendance upon the works for the purpose of remedying defects. So under the conditions precedents in PAM, PAM stated these costs are needed in order to achieve the certificate of making good defects. This is that clause 15.2, the certificate of practical completion, clause 15.4, the schedule of defects, the clause 15.6, the certificate of making good defects. So the same in PWD, and this clause in the condition precedent will include the clause 48.1a, the written instruction, the clause 48.1b, the schedule of defects, and also the clause 48.4, the certificate of making completion of making good defects. So the condition precedents in physics includes the clause 11.1, completion of outstanding work and remedying defects, and clause 11.1, the defects notification period, the DNP, and also the clause 11.6, the further test on remedial works, and also clause 11.9, the performance certificate, and the clause 11.11, the clearance of site. So under condition precedents in CIDB is included at the clause 27.1 defect liability, the DLP. So, and also the clause 27.6, the certificate of making good defects. So the defect liabilities period DLP is a common feature in all the standard form of construction contracts in Malaysia. So in PAM, PWD, and CADB, which is the commonly used standard form of contract in Malaysia, has stated the defects appear during DLP will automatically under the obligation of the contractor since is stated in the contract form. The contractor must carry out the remedial works to the defects stated in the schedule of defects, PAM and PWD, or written instruction PWD by the architect in PAM or the SO in PWD. As in FIDIC, DLP is rephrased as the defects notification period, the DNP. The contractor is required to carry out remedial works in defects notification period if it is not entitled to receive payment if the works was resulted of a defect in the design for which the contractors were responsible. After the completion of making good defects, the contractor will receive the certificate of making good defects in PAM and CIDB, the certificate of completion of making good defects in PWD, or performance certificate in FIDIC. So the third one, we will talk about the certificate of particular completion, the CPC. So the CPC is stated in PAM under clause 15, particular completion and defects liability, and also the clause 21, date or commencement, postponement, and completion of date. Then in PWD, the is stated under clause 39, completion of work, and also clause 48, defects after completion. And in FIDIC, is stated under clause 8, commencement, delay and suspension, and clause 9, the test on completion, and also clause 11, defects liabilities. And in CIDB, clause 20 is stated in clause 20, time for completion, and clause 21, the test on completion. So in PAM, the construction obligation is stated in clause 15.1a. The works are completed when the contractor has done make good defects within the reasonable time specified by the architect. So clause 15.2, the contractor shall give a written notice to the architect within 14 days to inform the architect the works done. And also in clause 21.1, the contractor shall commence the execution of the works and proceed to complete the same before the completion date. And the contractor's obligation will be stated in PWD in clause 39.1, subject to clause 38.3 and 41. The contractor shall complete the whole of the works on or before the date of completion. So also in clause 39.2, the contractor shall notify the SO in writing the works have achieved practical completion. And also in clause 39.4, the contractor shall not be issued the certificate of practical completion until the remedial works on two defects were carried out and done by the contractors. So in clause 48.1a, the SO shall issue a written instruction to the contractor to make good such defects at the contractor own cost within the DLP. So in FIDIC, the contractor's obligation is stated in under clause 8.2, the contractor shall complete the whole of the work within the time for completion, including the passing of the test on completion. So in clause 9.1, the contractor shall carry out the test on completion in accordance with clause 7.4. So also in clause 9.1, the contractor shall give the notice to the engineer not less than 21 days to notify is ready to carry out the time of completion. So in the contractor's obligation in CIDB, it's stated in clause 20.1, the contractor shall complete the works within the time of completion. And also in clause 21.1a, the contractor shall carry out the test of completion in accordance with the requirements of the contract. In clause 21.1b, the contractor shall give a notice to the SO that he is ready for the test on completion within 14 days. And also in clause 21.1c, the contractor shall provide the SO or test report required by the contract. So the procedures to achieve practical completion in PAM is mentioned in clause 15.2. When the contractor considers his work has complete, written notice shall be given to the architect within 14 days. If the architect found existing incomplete works, he has the right to give the written notice to the contractor as an information. So lastly, if the architect considers the works are practically complete under clause 15.1, the architect shall issue the CPC to the contractor. So in the procedures to achieve practical completion in PWE, firstly, it is mentioned in clause 39.2, the contractor shall notify the SO in writing the works have achieved practical completion. And secondly, under clause 39.3, the SO shall carry out inspection of the works within 14 days after receiving the notice. And also in clause 39.3, the SO shall give instruction to the contractor specify all defective works which are required to be completed by the contractor. And lastly, in clause 39.3, the SO shall issue the CPC to the contractor if in his opinion the whole works has reached practical completion. So in FIDIC, the procedures of achieve practical completion is stated in clause 9.1. The contractor shall carry out the test on completion in accordance with the clause 7.4. Also in clause 9.1, the contractor shall give the notice to the engineer not less than 21 days to notify be ready to carry out the time of completion. So in clause 9.4, if the test of completion and the contract price shall be reduced by such amount as the cover of the failure of the contractor. So lastly, there is in the clause 11.9, if pass the test, the engineer shall issue the performance certificate to the contractor as he has completed his obligation under the contract. So in procedures stated in CIDB, the CIDB also mentioned before the achiever of practical completion is also mentioned the test on completion before CPC. So is also stated in clause 21.1, the contractor shall carry out the test on completion in accordance with the requirement of the contract. And also, the contractor shall give a notice to the SO so that he's ready for the test of completion within 14 days. And also, the contractor shall provide the SO all tests required to the contract. And procedures to claim CPC in accordance with the clause 20.2b, the SO shall give instruction to the contractor in his opinion that the works is required to be complete before the issuance of the CPC. And then the contractor may issue the CPC if the whole works has passed the prescribed test by the contract. And the works will be handed over to the employees after receiving the CPC. So under the considered precedents in PAM stated that these clauses are needed to achieve the CPC. It is the clause 15.1, the works are complete when A, the contractor has made goods defects within the reasonable time specified by the architect, or B, the other requirements expressly stated in contractual documents as a prerequisite for the issuance of the CPC has been complied with. And lastly, and also the clause 15.2, the certificate of practical completion. So under the condition precedents in PWD, in clause 39.3, the certificate of the practical completion is needed to achieve the CPC. And in clause 39.5, the works shall not be regarded as practical complete unless it's fulfilled. The works has been complete in accordance with the terms and conditions of this contract. The government can have full and proper and beneficial use of the works for their intent purpose. May be minor defects which do not affect the beneficial work used of the works. The works has passed any commissioning test required in the contract document. The works shall be made available to the government in condition fixed for occupation, and also all essential service specified in the contract document is ready to go, is in ready to go conditions. And FIDIC, the conditional precedence, under the conditional precedence is the clause 11.9. The performance certificate will be issued after they have done all the remedial works. So under the condition precedence, CIDB stated these clauses are needed in order to achieve the CPC. So in clause 20.1, the contractor shall complete the works within the time of completion stated in the letter of awards, appendix, or elsewhere in the contract documents. And also clause 20.2, the certificate of practical completion, so the CPC. So in PAM and PWD and CIDB, the certificate that prove all works and obligations have been done is stated as the certificate of practical completion, CPC. FIDIC is the only standard form of contract that mentions this certificate as the performance certificate. Although the names are different, they share the same characteristic and they only can be issued after the test of completion. Another difference in the clause of certificate, the CPC between this standard form of contracts are PAM and PWD focus on the condition precedence, and FIDIC and CIDB focus more on the test of completion procedures, as in at least is the important works. So the fourth one is the CNC, the certificate of non-completion. So it is stated in clause 22 in PAM, damage for non-completion, and also in clause 40 for PWD, damage for non-completion also. So it's also stated in clause 8 in FIDIC, commencement, delay, and suspension, and also stated in clause 26 in CIDB, the non-completion and damage for delay in completion. So in the contractor obligation stated in PAM, is stated in clause 32.1. If the contractor fails to complete the works by the completion of date, the contractor shall pay or allow the employer a sum calculated at the rate stated in the appendix as liquidated damage (LD). And in clause 32.2, the contractor shall pay the employer the said amount if the same becomes due without the need for the employer to prove his damage unless the contrary is proven by the contractor. So in PWD, the contractor obligation is stated in clause 40.1. If the contractor fails to complete the works by the completion date, the SO shall issue the CNC to the contractor. So in clause 40.3, the contractor by entering into the contract agrees to pay the government's said amount if the same become due without the needs of the government to prove his actual damage or loss. So in clause 40.4, the liquidated and ascertained damage, the LAD, shall not relieve the contractor from his obligation to complete the works due to it is still under the obligations and liabilities in the contract. So in FIDIC, the contractor obligation is stated in clause 8.7. If the contractor fails to comply with time of completion, he shall pay the delay damage to the employer. Also in clause 8.7, this damage shall not relieve the contractor from his obligation to complete the works. And in CIDB, the contractor obligation is stated in clause 26.1a. The SO shall issue the certificate to the contractor if the works have not been completed within the time of completion, or any extended time granted as such certificate shall be referred as to the CNC. So the clause in clause 26.2a, the employer shall be entitled to recover from the contractor LD calculated at the rate stated in the appendix for the period from the time of completion. So the procedures under CNC, PAM mentioned that in clause 22.1 to 22.3, if the contractor fails to complete the works by the completion date, the architect will issue the CNC, and the contractor shall pay or allow the employers a sum calculated at the rate stated in the appendix as LD. If the architects issue a EOT, which has the effects of fixing the completion date, such certificate will be effected will affect the CNC. So if the works are not done within the DOT, or a further CNC will be issued to the contractor again. So in PWD, the procedures under CNC is mentioned in clause 40.1. If the contractor fails to complete the works by the completion of date, the SO shall issue a CNC to the contractor. The clause 40.2, the contractor needed to pay the liquidated the LAD calculated as the rate stated in the appendix 1 from the issuance of CNC to the date of the issuance of the CPC or termination of this contract. So thirdly, the last one in clause 40.4, the LAD shall not relieve the contractor from his obligation to complete the works due to its still under the obligation and liabilities in the contract. So in FIDIC, the procedures under CNC is stated in clause 8.7. If the contractor fails to comply with time of completion, he shall pay the delay damage to the employer. This delay damage shall be the sum stated in the appendix to the tender, which shall pay for every day. This damage shall not relieve the contractor from his obligation to complete the works. In CIDB, the procedures under CNC is stated in clause 26.1a and clause 26.2a and b. The SO shall issue a certificate to the contractor if the works have not been complete within the time for completion or any extended time granted, as such certificate shall be referred as the CNC. The employer shall be entitled to recover from the contractor LD calculated at the rate stated in the appendix for the period from the time for completion. And lastly, the payment or deduction of such LD shall not relieve the contractor from his obligation to complete the works from any others of his obligation and liabilities under the contract. So under the condition precedents in PAM, it stated that the liquidated damage and certificate of non-completion in clause 22.1 is needed to take note under the CPC. So, and also under the condition precedents, PWD is also stated in clause 40.1 and 40.3. The certificate of non-completion and liquidated and a certain damage is LAD. So under condition precedents in FIDIC is only stated that the delay damage in clause 8.7 is needed to take a note for the CNC. And under condition precedents in CIDB, it is stated in clause 26.1 and 26.2, the certificate of non-completion and liquidated damage. So even the simplest project has the inherent risk of being delivered after the time of completion stipulated at the conclusion of the contract, so that sometimes the delay will cause the construction works may not be done within the specific time frame. So CNC, the certificate of non-completion, shall be issued to the contractor who has not completed the works. All PAM, PWD, and CIDB has include the clause of CNC, while FIDIC has no mentioned terms like CNC, but all is included in the clause 8.7, delay damage. Delay damage is the amount stated in the contract appendix that should be paid when the contractor cannot complete the works given its specific time duration. In PAM and CIDB, it's called liquidated damage, and in PWD, it's called liquidated a certain damage. So lastly, the termination of contract by employer. So this is stated in clause in PAM in clause 25, determination of contractors employment by employer. And in PWD, this is stated under the clause 50, suspension of works. Clause 51, the event on consequences of default by the contractor. Clause 52, the termination on national interest. Clause 53, termination on corruption, unlawful or illegal activities. And clause 54, payments upon suspension and termination of national interest. And clause 55, the events and consequences of default by the government. And also clause 56, the certificate of termination costs. So in FIDIC, this is stated in under the clause 15, termination by an employer, and in CIDB is mentioned is the clause 44, determination by the employer. So in contractors obligation, PAM stated that in clause 25.4a and 25.4d, after determination, the contractor shall vacate the site and return possession of the site to the employer to let other person to carry out the works to be done. So the contractor is required to assign to the employer the benefit of any agreement for the continuation of the hire of the construction plant and equipment already inside. And the contractor shall pay the employer all costs incurred to complete the works, including all damage suffered by the employees. And the contractor obligation in PWD is stated in clause 52.1a. The government may terminate the contract without any provision. And clause 53.1, if the company is convicted by a court of law or corruption or unlawful activities in relation to this contract of many other agreement. In clause 54.3, upon termination of this contract under clause 50 and 52, a final account of this contract shall be prepared and issued by the SO. And in FIDICs, it is stated in clause 15.2, after termination, contractors shall then leave the sites and deliver any required goods. And in CIDB, the contractor obligation is stated in clause 44.3 A and D. So the contractor shall immediately cease all operation of the works, remove his personnel and workmen from the sites, leaving only the plant, temporary works, and buildings. And the contractor shall, if so required, the employer assign to the employers without payment the benefits of any agreement for the supply. So the procedures under termination of termination of contract by the employee, PAM stated in clause 25.2, the employers of architects shall give the contractor written notice to specify the defaults after decided to determine the contract. If the contractor shall continue with such defaults for 14 days from the notice, then the employer shall determine the employment within 10 days by a further notice delivered by hand. In the PWD, the procedures is stated in clause 53.2, consequence of the termination. The government shall be entitled to all damage, including any incidental costs and expenses incurred by the government arising from such termination. So that the clause 51.1c 1 and 2 shall apply. So the contractor shall not be entitled to any other forms of losses or whatsoever upon the termination of this contract. So in FIDIC, the procedures is that after the termination, the contractor shall leave the sites and deliver any required goods, and then the engineer shall proceed in accordance with the determination to agree the value of the works. After the notice of termination, the employer may withhold further payment to the contractor until the cost of execution, completion, and remedying have been established. So in CIDB, the procedures under termination of contract by the employers is stated in clause 44.1b. If the contractor continues with the certified contractor defaults for 14 days from the notice under clause 44.1a, then the employer, without prejudice to any other's right or remedies, may within 10 days from the expiry of the said 14 days period by further notice to the contractor determine the employment of the contractor under the contract. So the termination of contract by the employer is always happening in the construction industry. So when used in the context of construction contract, the word determination is employed in connection with the ending of the contractor's employment under the particular contractor. In the determination, if it is the contractor's obligation to and responsibility to carry out the works under the contract that is terminated and not the contract. So under the cause of termination of contract by employer, PAM has listed down the detailed obligation and liabilities of the contractor after termination. PWD has listed many detailed sub-clause for under the termination of contract. And the Felix shows how does the termination process work in the international aspects. And in CIDB has more focus on the condition precedence listing and mention the condition need under the determination. So as a conclusion, construction project can be one of the most challenging projects undertaken by any business company nowadays. And a properly drafted construction contract can be the key to a successful project by establishing the expectation, the rights, and responsibilities of the employer, contractor, and other parties involved in the modern construction project. Given the vital role a good contract can play in a successful construction project, it's important to put in place a contract that meets the needs of your specific project. So all the 4 standard forms of contract, PAM, PWD, FIDIC Red Book, and CIDB, they establish the bodies of case law that can be referred by parties in case of disagreement over any issues. This will benefit the whole construction players and boost the rapid growth of the construction industry by letting all construction players to understand, to know more about the contract, how the contract clauses works. And so this is the end of my presentation, and this is the reference where I get from my findings, and thank you very much.